Hello and welcome to another edition of iDS Talks. My name is Hunter McMahon. I'm the COO of iDS, and I'm joined here today by Neal Weinrich of Berman Fink Van Horn. Today, we're going to have a great conversation about non-competes, the favorite topic of many. Now, before we get started, Neal, will you give us a brief intro, sir?
Yeah, absolutely, Hunter. Thanks for having me on today. Again, my name is Neal Weinrich. I'm a shareholder with Berman Fink Van Horn in Atlanta. I'm a commercial litigator, but a heavy part of my practice is focused on non-competes, other restrictive covenants, trade secret law, unfair competition issues, help companies and individuals kind of navigate transitioning from one company to another when a company's hiring someone and needs advice regarding a non-compete, or they've have an employee leave and need advice regarding that company's obligations. That's kind of where I step in, and excited to chat with you about what's going on in the non-compete world today.
Awesome. And for our listeners, a fun factoid about Neal and I is we actually first met about 6 years ago when he happened to help me navigate some non-compete obligations I had at the time. So it's fun to be collaborating now, Neal, instead of having to seek your advice. No offense.
Absolutely. A lot of clients tell me that.
Very nice. So Neal, we've all heard of it, the changing landscape of non-competes, what the FTC is proposing. Give us a quick summary. What does everybody need to know about the landscape right now?
Yeah, it's definitely interesting times in the non-compete world, Hunter. If you kind of go back the last 10 years or so, really the linchpin perhaps for what we're ultimately seeing today is the Jimmy John's case that we all read about in the news. I think it was 2014. You had Jimmy John's was making college students and other Jimmy John's employees sign a non-compete that said they wouldn't work within 3 miles of not just any Jimmy John's location where they worked, but any Jimmy John's location anywhere in the world. And not surprisingly, that was viewed by attorney generals both in Illinois and New York as abusive and concern for labor and bad for consumers and bad for everybody. And that was really the first time that non-competes really kind of were in the public spotlight, where you had the Wall Street Journal and New York Times kind of writing about non-competes. And since then, we've seen, both at the state level and to some degree at the federal level, attention given to how can legislative or administrative bodies address the issue of the abuse of non-competes. Because what the Jimmy John's issue did is it laid bare for the public that, and a lot of people that have been asked to sign non-competes know this, and there are companies out there that are using non-competes when it's probably not appropriate to do so. I think we could all agree that the sandwich worker at Jimmy John's it's not warranted for that employee to be subject to a non-compete. There's no secret sauce about how to spread the mayo on a roast beef sandwich. So from the Jimmy John's saga, we've got during the Obama administration, you had working groups that kind of came into the White House, and a Treasury report that kind of talked about the increased prevalence of non-compete and the negative impacts that has for the labor workforce. You still have agencies kind of taking a look at this issue, some additional workshops during the Trump administration. Once Biden gets elected, his platform expressly mentions addressing the overuse of non-competes, except in the limited instance where they're used to protect trade secrets. And the Biden administration, issues an executive order directing the Federal Trade Commission to tackle this issue. The FTC has some additional workshops, and then ultimately this January, really two things happened. First, the FTC announced that it had entered into consent orders with several companies that it had investigated for abusing non-competes. And then the day after, we all kind of heard about these enforcement actions, which that caught everybody surprised. The FTC announced that it was issuing a proposed rule that would effectively be a complete ban on non-compete agreements, especially in the employment context. So that's really kind of what's going on at the federal administrative level. And at the same time, One kind of product of the workshop during the Obama administration was effectively a call to action to the states saying, here are some of the abuses that are going on. Non-competes are being used with low-wage workers. There's a lot of kind of fairness problems that employees are, the non-competes being stuck in an agreement that's on the pile of documents that they have to sign on the first day of work after they've sold their house in Detroit and, moved down to Tampa, Florida. They're like, wait a minute, no one told me about that I was going to be subject to a non-compete agreement. So just these kinds of issues of fairness, this call to action, it was encouraging. The idea was to encourage states to tackle these issues. And in the last, 5 to 7 to 8 years, you've seen a lot of activity at the state level where more states are, addressing these issues and passing legislation that either reduces the categories of employees that, depending on their wages, can be subject to non-competes, or imposes requirements such as notice requirements or additional consideration requirements that are designed to make non-competes fairer. But the FTC has now jumped in and issued this proposed ban, which would go beyond kind of where most current states are in terms of banning non-competes.
So if we go back though, and the purpose of a non-compete, I'm gonna come at it from a business perspective, not necessarily a legal perspective. In essence, I wanted to protect what I had built, and you had come in and benefited from a wage standpoint. If you knew how to do something in a secret way that I had created, and I didn't want you to be able to go down the street and in essence take that knowledge, that trade secret, that proprietary information, and use it for a competitor for their advantage, right? So that there was a business interest there. Is the FTC coming in and saying, we get it, but they've been abused so much that absent exception, there's not something that you should be able to protect from a compete status?
Yeah, so the FTC's ban goes far. Like I said, it is effectively a complete ban on all non-competes in the employment context. So even that, and the CEO of Coca-Cola that obviously has trade secret, highly sensitive competitive information about business strategies, business plans, marketing strategies, or the R&D person at a biotech company that is working kind of on the cutting edge of some proprietary research that is obviously kind of critical to that company's business plans and kind of future revenue and profitability. The FTC is effectively disregarding those considerations and saying, we think at the end of the day that non-competes are bad for the economy, that they're bad for the labor workforce and labor mobility, and that the competitive market will be better if non-competes are taken out of them. So
now, real quick on clarification, just to make sure that we're talking the same language. I talked about confidential information. You mentioned trade secrets, proprietary information. The non-compete just says you can go across the street and work. It does not say, the ban on non-competes does not say that you can take this information and go across the street and work, though that information is still protected.
Yeah, that's correct. So a non-compete just says you can't go work for a competitor. You can't set up your competing business. Typically these types of agreements have separate non-disclosure covenants that say you can't take the confidential information, you can't take the customer list. And obviously there's federal and state trade secret laws that protect against and restrict employees from taking information that rises to the level of a trade secret. What a lot of companies would say is that the non-compete serves as a prophylactic for preventing trade secret theft or confidential information that is difficult to identify, right? The higher level executive that is intimately involved with the company's most secret sensitive plans, that executive if they go to the competitor down the street, they may have all the good intentions in the world, but it's really hard to keep the toothpaste in the bottle, right? All that sensitive information that's in their head, if they're in a role that is similar for a competing company, then it's difficult to not use the confidential information or trade secret information that they've agreed to not to use.
Because at that point it's knowledge. It's not necessarily a document that they may have taken the formula on a spreadsheet or on a literally written on a card or something to that effect. It is the knowledge in their head. So how can they not think about it?
Exactly. It's that intangible information that even though it's not reduced to a file or a document, it still could be having proprietary and sensitive and competitively advantageous.
But one of the things you said earlier that is interesting is that this seems to be a way of bringing federal or across state lines commonality as to the standards as opposed to state by state. Because I know for many years, if I just looked at coastal and said, well, Georgia's very different than California, as you and I discussed 6 years ago, it is very different, or it has been historically. Is that the primary purpose to the FTC's proposed ban, insofar as now we can bring everything to a common resolution?
Yeah, I think the FTC is looking to create some uniformity. I think from the FTC's perspective, it's more about this is the way it should be. We think that the way California is doing it is the right way, and that there's only a few other states like California that do have complete bans on non-competes, and the FTC has concluded that that's essentially what's good for everybody. I don't know that the FTC has uniformity in mind as a specific objective, but obviously when you've got a federal law or federal regulation, the result of that is you end up with uniformity on an area, something like this.
Well, especially as a lot of companies have gone remote and more distributed, I can imagine that eases some of the, well, what do I do in this state versus that state pains from a business standpoint. But it did strike it down, or it does propose to strike it down all in its entirety. So I guess you got to take the good and the bad.
Definitely. And that is a challenge for organizations that have employees in multiple jurisdictions is, how do you draft restrictive covenants that are going to be enforced against the employees in Washington? And what do you do about the employees in California? But Florida allows more liberal enforcement. So do you treat those employees differently? And, how dealing with that and managing that within an organization, coupled with the fact that these laws are changing on a weekly, monthly basis, particularly since the FTC introduced this ban. There's just a host of states that are considering new non-compete legislation, and so things are changing by the day, by the week, and that's challenging for organizations and even their lawyers to keep up with all the changes that need to be considered when you want to make sure that you're not tripping up and stepping in a landmine and using a non-compete when you're not supposed to.
Well, let's talk about that. I mean, is this something that companies need to be proactively evaluating now, or is it more of a wait until it comes up kind of scenario?
It's a great question, Hunter. Right now the ban is just the proposed ban. It's a proposed rule, and it goes through the process that any proposed regulation goes through. So originally there was a 60-day comment period. This particular rule has gotten a lot of attention, and they've extended the comment period by 30 days. Last I checked, they've gotten over 20,000 comments. So it's going to take some time for the agency to process that, review all that.
Somebody's got some weekend reading.
No kidding. I don't envy the stampers at the FTC that have to mine their way through lots and lots of comments, some of which are just members of the public that may have had a negative experience with non-competes that they write in a paragraph, and some of those are highly robust comments, very substantive from trade organizations on both sides of the aisle on this that have views that have kind of laid out the reasons for why this is good or why this is bad. So there's got to be some period of time before we know whether there's a final rule, if it looks different than the existing rule. There's certainly some aspects of the rule that the FTC's explicitly said that it's interested in receiving comments on, and it may take a different approach when it issues a final rule. So I do think there's the things that I think companies need to sort of immediately do while this rule is out there is make sure that they're not using non-competes with low-wage workers, with individuals, types of employees that are going to potentially subject them to the kinds of enforcement actions that we've seen from the FTC. That's, I think, the biggest takeaway in terms of kind of what to do immediately is don't put yourselves kind of in the crosshairs. I think as far as the what to do right now about the proposed ban that's coming, I think a lot of companies are going to take a wait and see approach, because there is this sentiment that the FTC is going farther than it's allowed to do, and that there's likely going to be legal challenges to the validity of the rule, and that those challenges may end up being adjudicated before the compliance period that companies have to comply with the rule if it ends up going into effect.
So what I'm taking away is be mindful, know where you stand with your current non-competes, because I know many may not have an active inventory or understand their various versions that have rolled out through the years, and understand what areas of compromise you might have to have. Is that a fair summary?
Yeah, I think that's a very good summary. I think you want to, again, just make sure that you don't want to be using non-competes with the employee that's making $13 an hour. That's the kind of thing that, if the FTC learns about it, the FTC is probably going to have a problem with it. And do they have the bandwidth to investigate and initiate an enforcement action against every company that is doing that? I mean, they may not, but I think companies that are the ones that maybe are engaging in the abuses that, really kind of led us to where we are, those are the companies that should go ahead and kind of act cautiously now. And there's other things that I'm happy to talk about that, companies can be doing either in anticipation of the ban going into effect, or even if the ban doesn't go into effect.
Perfect. Let's hear them.
Yeah, the first one is, companies we've been saying this for a while, especially since there's been a federal law that allows companies to protect trade secrets using a federal statute. Companies should be taking steps to, what are they doing to make sure that their most sensitive information is secure and protected, both from an IT standpoint, from a training standpoint, from a culture standpoint, from, legal documentation standpoint. Is if we end up in a world where we're not allowed to use non-competes, even with the senior most executive that is making a 8-figure salary, companies need to make sure that the trade secret information is protected, and that they're doing the kinds of things that will allow them to still protect their information and their competitive interests. If there's not non-competes. Because what's happened in California, where you don't have non-competes, is there's more trade secret litigation in California than anywhere else. And, obviously non-competes are a tool that companies use and companies have used to prevent prophylactically against trade secret theft. But if non-competes are out the window, we're just going to see, more and more trade secret litigation and trade secret disputes. The cases that were non-compete cases, those may very well end up being trade secrets cases. And that's what happens a lot of days. And the kinds of cases I handle is, we learn that somebody is breaching their agreement by working for a competitor. We engage iDS, someone on your team, to do an analysis of that employee's computers or their emails. And lo and behold, we discover that not only are they violating their agreement, but they copied everything from Salesforce, or they copied their ARC drive, or they emailed a bunch of documents to themselves.
Users never do that. Said nobody ever.
That's right.
We see it all too often. I think the favorite example of that one I like is somebody had labeled the folder on their desktop "Take before you leave."
That's a good one. I hadn't heard that one. That's the definition of a smoking gun in a trade secret case, right?
It was pretty good. But what you're saying in your first point is really make sure that you've got the ability to prove that you've secured your trade secrets before the incident in question, so that you're taking the proper measures. And you listed a bunch of them, whether it's a technological security or whether it's training, culturally, who had access to what, so that you can prove that it was protected.
Exactly. Yeah, you want to make sure you have the right agreements in place. You want to make sure you've got the security that you need. You have to go convince a court that this is sensitive information that the company treats like a trade secret. Those are the kinds of steps that companies need to be taking. Obviously, the goal is to prevent the information from leaving the organization, but the secondary goal was to make sure that if we have to tell a court that, hey, this is sensitive information that shouldn't have been and is being used unfairly, it should never have been taken, the court's going to want to see that the company treated it like sensitive information.
Most certainly. So what else can companies be doing?
The other thing that I really think companies need to think about is the kinds of deals or contracts that companies enter into during this period where there's this uncertainty about whether there's going to be a broad non-compete ban. Companies need to kind of have in the back of their head, will I be happy with this deal that I'm doing if a non-compete ban goes into effect? So suppose a company executive is being paid $750,000. They're leaving the organization, but they're going to have essentially 2 years garden leave and a non-compete attached to that as part of their severance package. If the FTC issues a ban come November, December, September, whenever it is, all of a sudden the company may have paid this substantial severance consideration and no longer has the benefit of the non-compete that they negotiated to get in paying that large severance. That's something that's just an example. Another example is, and it's one thing we didn't really get a chance to talk about earlier, is not only does the ban applies to all workers, so any employee, any contractor, even any volunteer, any intern can't be subject to a non-compete. There is an exception for a non-compete that's entered into in connection with the seller of a business, but non-competes would only be allowed for a seller that sells more than 25% of their business.
So that's interesting. That's a very key clarification.
Yeah, and it's a little bit of a arbitrary number. Suppose that someone had a $250,000 company, and let's say there were two people, and they each own 50-50, and they sold this small business. And since they each own 50%, they could each be subject to non-competes. But suppose 5 buddies from college start some incredible technology company, and that company is now worth $1 billion, and they each own 20% of it. So they're each getting $200 million in that transaction. None of them can be subject to non-competes because none of them own more than 25% of it. Which that's something that I think a lot of us that are following this closely, we hope that maybe the FTC will take a closer look at that and kind of maybe take a different approach on that if and when it issues a final rule. But I think companies that are, doing deals and doing transactions need to be mindful of, if this is a deal where a significant part of the consideration that we're paying for is the seller's non-compete, and maybe it's a founder that now they only own 18%, but the company really wouldn't want that minority seller out there competing, and the company just needs to be mindful that this ban is lurking and could impact the deal that they're negotiating.
That's an interesting perspective. I have been thinking about this from the employment standpoint. You cornered that pretty early, but this could even impact the transaction market, the business transactions. I mean, from an investment and a purchasing of businesses, pretty significantly.
Absolutely, and it's something that I would think that the deal market is probably paying close attention to, and companies, a deal that is valued at X dollars when it includes a non-compete for some of the key people, that deal may be valued at something less than that when you can't get the non-competes that you're looking for that are a key part of a sale. Deals will look a lot different if this ban does end up going into effect, and I think it's something that folks that are involved in deals need to be thinking about now.
Wow. Well, I'm certain this is not the last that we'll hear of this year, let alone in years to come. But Neal, thanks for joining us today, and of course, our listeners. If you'd like to learn more about IDS, please subscribe or you can visit idsinc.com or wherever you normally get your podcast. Again, thanks for joining us, and we look forward to talking again on our next edition of IDS Talks.
Thanks so much for having me, Hunter.